This hearing concerns the confirmation of charges by the prosecution against Mr. Duterte. At this stage of pre-trial proceedings, the OTP alleges that Mr. Duterte is responsible for the crimes that the course officer shall read out shortly. The Chamber shall not take any decision with regard to the guilt or innocence of Mr. Duterte during this hearing. Indeed, the role of the Chamber is to determine whether there is sufficient evidence to establish substantial grounds to believe that Mr. Duterte committed the crimes with which he is charged. If all or part of the charges are confirmed, the Chamber will refer the case to trial, where the trial chamber will decide upon the innocence or guilt of Mr. Duterte. The general principles to be applied at the hearing are as follows. The suspect, in accordance with Article 66 of the Rome Statute, the suspect is considered to be innocent until his guilt has been proven by the court. The burden of proof is upon the OTP, which must produce sufficient evidence to prove the charges against Mr. Duterte at the required standard of proof, at Article 61, paragraph 7 of the Rome Statute. Finally, the defense enjoys, or the suspect enjoys, all the rights listed at Article 61, paragraphs 6 and 67 of the Rome Statute. The hearing shall take place according to the schedule contained in the order dated the 26th of January 2026, document number 359. The parties and participants must respect the allocated speaking times indicated in this order. I would like to remind the parties and participants that oral remarks must be concise and that repetition of previously presented arguments should be avoided. In addition, in order to facilitate the work of the interpreters and ensure the proper transcription of discussions, please make sure that your microphone is on every time you address the court. And please speak slowly and mark pauses between each sentence. Generally speaking, the hearing will be held in open session, and parties and participants will refrain from mentioning the names of victims and witnesses. They will only refer to them by their pseudonym or their code. In order to avoid the disclosure of any confidential information, notably with regard to witnesses and victims, the parties and participants will clearly indicate whether their submissions can be presented in public or whether they deem it necessary to move into private session, notably when referring to items of evidence. The parties and participants will clearly indicate when it is no longer necessary to remain in private session. With these rules in place, we can now move to the reading of the charges in its shortened form, indicating the charges against Mr. Duterte. The full version is available publicly on the internet site of the court. The defense has not raised any objections in this regard. I would like to remind the public that the charges that shall be read out in a few seconds comprise allegations raised by the Office of the Prosecutor that the Chamber shall decide, that shall analyze in order to decide whether the evidence presented by the Office of the Prosecutor is sufficient in order for these charges to be confirmed. Madam Courtroom Officer, would you please read the charges?
The prosecution charges Mr. Rodrigo Duterte with 2 counts of murder and 1 count of murder and attempted murder as a crimes against humanity committed between 2013 and around June 2016 and between around July 2016 and September 2018 in the Republic of the Philippines as follows. Count 1. Murder of 19 victims alleged to be criminals, including 3 children, who were killed in or around Davao City in the Philippines between 2013 and around 2016 by members of the Davao Death Squad, while Mr. Duterte was the mayor of the Davao City pursuant to Article 71A of the Rome Statute. Count 2. Murder of 14 victims labeled as high-value targets for their alleged criminality, who were killed in locations across the Philippines between around July 2016 and July 2017 by a network of perpetrators comprising state actors and others, referred to as the National Network, while Mr. Duterte was the President of the Philippines pursuant to Article 71A of the Rome Statute. And count 3. Murder and attempted murder of 45 victims, comprising 43 murders and 2 attempted murders of persons alleged to be criminals, including 3 children who were targeted in barangay clearance operations in locations across the Philippines between around July 2016 and September 2018 by members of the National Network, while Mr. Duterte was the President of the Philippines pursuant to Articles 71A and 25(3)(f in respect of the attempted murder of the Rome Statute. The prosecution alleges that Mr. Duterte is individually criminally responsible for all 3 of the above counts as follows. First, as an indirect co-perpetrator pursuant to Article 25(3)(a of the Rome Statute. At least between 1st November 2011 and 16 March 2019, Mr. Duterte and his co-perpetrators shared a common plan to neutralize alleged criminals in the Philippines, including individuals perceived or alleged to be associated with drug use, sale, or production, through violent crimes including murder. Mr. Duterte and his co-perpetrators implemented this common plan through the hierarchically organized structures of the Davao City Police, Police and Davao Death Squad, and then the National Network. Within the framework of the common plan, Mr. Duterte made essential contributions to the crimes in counts 1 to 3 by A. Designing and disseminating the police to neutralize alleged criminals, both in his role as a mayor of the Davao City and also during his presidential campaign and as a president, including by endorsing the anti-illegal drugs campaign Double Barrel. B. Establishing and overseeing the DDS. C. Instructing and authorizing violent acts, including murder, to be committed against alleged criminals, including alleged drug dealers and users. D. Providing personnel and other necessary logistic resources such as weapons including those to be used in the execution of the crimes. E. Appointing key personnel to positions which were crucial to the execution of the crimes. F. Offering financial incentives and promotions to police officers and hitmen to kill alleged criminals. G. Creating and maintaining a system in which perpetrators knew they would be protected, including through promises of immunity and shielding perpetrators from investigation and prosecutions. H. Making public statements authorizing, condoning, and encouraging killings of alleged criminals, both as a mayor of the Davao City and as a president of the Philippines. I. Authorizing state actors to take part in the anti-drugs campaign and temporarily revoking such authorization, including to placate public outcry. J. Publicly naming individuals and holding up charts from lists of alleged criminals, including so-called high-value targets, some of whom were subsequently killed. Second, in the alternative, Mr. Duterte is charged with ordering and/or inducing the charged crimes pursuant to Article 25(3)(b) of the Rome Statute, and/or aiding and abetting these crimes pursuant to Article 25(3)(c) of the Rome Statute.
Merci, Madame la Greffière.
Thank you, Madam Courtroom Officer. With regard to objections and observations under Rule 122, paragraph 3 of the Rules of Procedure and Evidence, the Chamber notes that the defense submitted a number of written observations, and the last of which was on the 16th of February 2026, to which the OTP and the legal representatives of victims responded, respectively, on the 17th and the 18th of February 2026. On the 20th of February 2026, the Chamber dismissed, in its public decision, the defence's objections, in specifying that the defense and the Office of the Prosecutor are not permitted to reiterate the same arguments already presented in the filings mentioned, that they filed to date in this case. I will now ask if the parties wish to make any oral submissions on this point before moving to the opening statements. Mr. Deputy Prosecutor? Mr. Nyang, we do not have any submissions to make in this regard. Thank you very much, Mr. Deputy Prosecutor. Counsel?